Hello, welcome back to another edition of Between Two Fars. I'm Warnicki Miller, and I'm joined once again by Judge Reid Prouty, Vice Chairman for the Armed Services Board of Contract Appeals. And Judge Prouty has spent time active duty in the Air Force, and he was also a contract litigation attorney with the Department of Justice before joining the Armed Services Board of Contract Appeals 7 years ago. Today we're going to start talking a little bit about avoiding litigation and maybe how to fix problems before you end up in front of the ASBCA. So I got to ask you, have you ever been looking over a case and you kind of think, what was the agency doing? 6 months ago, why didn't they do ABC? Have you ever had a situation where you're going through the case file and you're just thinking, why didn't the agency fill in the blank?
Absolutely. Happens all the time. And it's not fair, right? Because we have 20/20 hindsight. So of course, it makes sense to us later on looking at it that, gosh, what were they thinking? But of course, it made a lot of sense at the time. And there's a couple of different ways that the agency could better protect itself or avoid litigation that we see. One way, and there's sort of one flavor I would say, is when the agency could have protected itself better by having a waiver or something like that. I'll give you an example. There was a case, it actually just came out about a month or two ago, called Metro Machine. You can look it up. This, by the way, is...
And you know what? We'll go ahead and we'll put the citation right here if you want to read that case.
And the citation isn't out quite yet because it just came out about a month ago, but Warnicki will get it you up to date. In that case, it involved overhauling a Navy destroyer. And there were delays, so a liquidated damages clause was invoked. And then the Navy contracting officer met with the contractor, and they agreed to knock a couple of days off of liquidated damages and also throw a little bit more money at the contractor. And it seemed like a bargain was struck, which would be, accord and satisfaction, a bilateral contract modification, all is great. If you read the email traffic, it was really clear that they sort of had a deal, but they neglected to put it into a contract modification. So even though everybody thought they had a deal, they didn't. And it might well have been that while the Navy had a relationship with the contractor, this lawsuit wound up being essentially a subcontractor pass-through. So the sort of deal, the sort of wink and nod handshake deal they had with the contractor didn't really count because the third party, the subcontractor, wasn't part of that deal and wanted its justice. Now, in the end, it didn't matter in that particular case, except that a whole lot of expensive litigation could have been avoided if what was understood and accepted to really be a deal had been just formalized. So that's one kind of thing you might want to keep in mind. If you're going to make a deal with the contractor to sort of basically settle a dispute, be clear about it. Put it in writing, do all the waivers, do all the waiver language, and do it clearly, and make sure everybody understands exactly what they're waiving and what they're not. That's the sort of first big piece of advice. Now, most of you would say, well, of course we would do that. But we also have a feeling that sometimes as people, when there's contention, nobody wants to be mean, nobody wants to be uptight, nobody wants to sort of make it too formal. But formality is actually everybody's friend because it lays out clearly what's expected of each party and could save you the much more difficult issue of having litigation. So that's sort of where the government does not protect itself. But sort of the other side of the coin is when the government doesn't protect the contractor, or when it sort of puts itself in a position of, for lack of a better word, being mean when it doesn't need to be mean. Look, there's a whole cause of action called breach of the duty of good faith and fair dealing, which is a big mouthful and is kind of wishy-washy. But at the end of the day, what it means is you're supposed to help the contractor succeed, at least not go out of your way to prevent them from succeeding. So when you're actually doing your contract performance, act as if you want the contractor to succeed, which of course you do want the contractor to succeed. If, for example, I'll give you shop drawings, if they give you bad shop drawings and you kick them back, well, tell them what's wrong with them. The contract probably lays out exactly how much you need to tell them. Tell them enough, even if it's beyond what the contract says explicitly, so they can fix it. Again, act as if you're invested in their success, because you are. And it will also sort of help pay dividends in helping you avoid litigation. And a final thing to move on to is terminations for default. Oftentimes you have terminations for default based on late delivery of things, which is the way things go. And oftentimes, I understand, especially at NASA, you are cases where, well, we'll let it slide for a few weeks or 3 or 4 months or whatever, and then at some point you run out of patience.
Yeah. You're wanting to see them succeed. You're wanting to give them the benefit of doubt. You're wanting to be able to be accommodating. But if you do that too much, it can come back to bite you. There does need to be that certain amount of formality if you're planning on going after contract remedies.
Exactly. And actually, sometimes it's cruel to be kind. And by that I mean, say, okay, we'll extend it. And sometimes a contract will do things like, okay, well, because it's extended, I'm having trouble getting this because of the supply chain issues, or whatever the case might be this year. And if they keep on acting as if the contract hasn't been terminated and they're trying to perform, they might be having costs imposed upon them. And then when you pull the trigger and you terminate them, you sort of strung them along. And that's going to make them not very happy. They'd been better off if you'd said, hey, you're late, let's cut this off, and they wouldn't have incurred all these expenses. Now look, there are times when it's really appropriate to extend the time. And you should do that when it works best for everybody involved, especially you, because you're looking out for your agency. And there are times when, it's just not going to happen. And don't string the contractor along in those cases. Be really clear about, hey, we're going to extend it by this much, but not any further. Be very clear about if you're incurring any costs, it's on you, so they can make an informed choice. And if they get terminated for default, maybe they won't sue, or at least maybe they won't have the waiver defense that, hey, I was strung along, I incurred all these costs, I thought there was no longer a deadline, or a deadline far, far, far in the future, which is a defense before the board and any other venue. So those are the kinds of things that you can do to make life better. So on the one hand, be formal, but on the other hand, also treat your contractor with respect and act like you want them to succeed, because you do.
Yeah, it sounds like if you reach an agreement about extending the schedule and how you're going to treat incurred costs, it sounds like maybe a bilateral contract modification with a release and waiver might be a good idea at that point.
Bilateral contract modifications are your friend.
Yes.
And make sure they're signed by both parties too.
Yes. Well, this is some great insight to help us stay out of your jurisdiction and maybe avoid some of the claims that we might otherwise have. Now, we're going to continue talking with Judge Prouty because we've got a lot more to cover about the ASBCA and our potential litigation in that forum. So join us again next time for another edition of Between Two Fars.